This is a great question, and I will give you the 3-minute answer that I am allowed to give on this platform versus the 15-minute answer that I would give you in my office. Generally speaking, a revocable living trust is intended to be a probate avoidance tool, not an asset protection tool. And the reason for that, it is an alter ego of you. So you are the grantor or settlor, the person creating the trust. You are also the trustee, or the person who manages assets and can write checks. And you are also the beneficiary. Well, if you wear all three hats and you have a judgment against you, the judge can order you as trustee to write you a check as the beneficiary and require you to turn that over to your creditor. In an irrevocable trust, as long as it is properly set up as a asset protection trust, then we separate the duties of grantor, trustee, and beneficiary so that we can tell the judge, I'm sorry, this was my money, but sometime before this incident occurred, I put my money in this separate legal entity, a revocable living trust, and I am not the trustee of that trust, and so you can't force me judicially to put an order in for me to write myself a check or write a check to my creditors. And by the way, Judge, you don't have jurisdiction over my independent third-party trustee who's not a party to this action. They're not a defendant here, and you can't control them. So that's a very simplistic answer. I'm sure some of the detailed folks will yell at me for being too general, but that is kind of the answer. A irrevocable trust, when properly drafted and funded, works much like an LLC or any other type of corporate structure. It's a separate legal entity. It has its own tax ID. It should be treated with arm's length transactions. You should not use it as your piggy bank. There's a lot of little rules that go along into it. But the general proposition is a irrevocable trust acts more like a company. And if you get sued personally, then it makes it much more difficult to get to company assets. That being said, if you check out my sister channel, Fortress Asset Protection, we'll talk about the differences between single-member LLCs and multi-member, and why multi-member give you more protections in the corporate world. However, for irrevocable trust planning, you do not need to have a multi-member organization. Hope this helps. If you have other questions, please drop me a comment. I love them, and I will always answer them. Take care.